Hi, welcome to Take from Caesar. I'm your host, David Myrland. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Believe it. This is an expose on exactly that fact. You bet. The law does not matter. A lot of people, well, there aren't a lot of people that listen to me, but the ones who do and who have listened to me a lot have heard me mention this document many times. It's the government's trial brief from the trial of U.S. versus James R. Back, a Pete Hendrickson tax return filer, done in the name of Karen Loeffler, U.S. Attorney, and Thomas Bradley, Assistant U.S. Attorney, Aaron S. Mellon, Trial Attorney, Tax Division. Now remember, these are the folks that say Tax Code Section 3121E describes U.S. citizenship, and they're proud to argue it to send people to prison. Don't forget that a definition of citizen that expressly excludes U.S. citizen, these people love arguing that, oh no, that's frivolous, meritless. They can't even bring that into this courtroom, Your Honor. I can't believe they would do that. They should be embarrassed that you argued the law that they can't refute. It's that bad. This is the government's trial brief, filed a couple weeks before trial in 2014. Here we have it, right here. Case number, document number, small document number, going into a tax trial. Only 77 documents filed. Filed September 22nd of 2014. It's a 24-page memorandum. We're going to go through the whole thing. There's a few things I want to bring out of this. This is a, a tutorial that I've wanted to do for quite a while, but I revisited it several times in the last couple weeks, and I think I'm ready. You see, I've added footnotes to it. Here's what that looks like when the footnotes aren't showing. There's that little ribbon over here. Click on the ribbon, and I got, look at the text below this video when it appears on YouTube. There will be a link to this brief with the notes that I've added to it, which aren't really substantial at all compared to what I could do to this memorandum. And with the understanding that, he sure talks big of himself. We just went to the Supreme Court 3 times last year. And 40 provisions are a secret. You can't have them. And let me tell you, if a statute screwed you, the government will take it out and they'll screw you with it. I use provisions they won't talk about, including Section 83 that explains how to tax the entire workforce. Now, this man was a Pete Hendrickson tax return filer. Count 1, false tax return. Count 2. Count 3 and 4. 4 is failure to file. 5, 6, and 7, failure to file tax returns. And you'll see them accuse him of spending his money. It's a criminal act now to spend your money. Well, if not, then why even mention it? Of course he spent his money. Oh, in this year he spent X number of dollars, Your Honor. So what? It's what you do with, it's called the right to acquire, enjoy, and dispose of property in any legal way. And in this document, it's an overt act in a scheme to defraud the government. Now, in this memorandum from the United States government, you won't see him mention law. His wages were gross income, Tax Code Section 61A. They never bother to say that. They just say wages or income. They just say it. And they don't anchor it to the language of any statute. So this isn't a trial brief at all. It's a narrative. They have something they want to accomplish, and so they use the language, the lexicon, that will help best paint the defendant, James R. Back, in that light. Isn't that easy? It is for a deviant. And we're going to look right at it. Another thing that slaps me in the face on this. As to what's on a defendant's mind regarding criminal intent should not be left up to eyewitnesses, laypersons. We need the jury to decide. The jury doesn't even know me. And I have other people that have known me for years, and they've seen me do this, they've seen me do that. And this is any number of tax protesters out there. They have this argument to make, and they don't, because the movement keeps them stupid. But I have, let's go to the top of the list. My spouse knows everything I'm into. She knows my beliefs. He knows my beliefs. Whoever you happen to be. A spouse that's in the same bed every night. And you're going to let the jury determine what's on my mind? Witnesses can't testify as to the state of mind of the defendant. Why not? They're around him all the time. They're around her all the time. No, it's the jury that will decide because they don't know anything about his state of mind. And we'll just make a bunch of inferences. Oh, look, he spent his money. Oh, no. And he admitted to earning this much in wages. So, everybody has to admit it. Next, it's insane. Criminally insane. The frame that I'll be able to point out to you in this government's trial brief. It's vague when it needs to be. It's very specific when it serves the government against the defendant. When in fact, most often, it's meaningless when they do it. Let's begin. Status of the case. This is 24 pages long, but you see it's double-spaced. We're going to go through the whole thing while I inject my commentary. Trial is scheduled to begin on Monday, September 29th, and this is filed on the 22nd, 1 week before trial. Plaintiff is represented by this guy, and attorney Aaron S. Myrland of the tax division for the West Coast. The defendant is appearing pro se. Right there. Warning bells. Pro se, and he filed Pete Hendrickson tax returns. That's, we're all gonna die. It's terrible news. He's pro se. If he had an attorney, he ends up getting 16 months in prison for those 7 counts. Found guilty on all counts. The defendant is appearing pro se. Assistant Federal Defender Jamie McGrady was appointed as standby counsel. Jamie McGrady. Who is Jamie McGrady? I'll tell you who Jamie McGrady is not. Jamie McGrady is not an attorney that can interpret Tax Code Section 83 that explains how to tax the entire workforce. The defendant, James R. Back, for these taxable years in controversy, was an employee. And his public defender can't even interpret the statute that explains whether or not he has a relationship with the government to begin with when all he does is sell his labor. Next paragraph. Discovery has been provided by the United States. Reciprocal discovery has been requested, but none has been provided. Copies of the government's trial exhibits will be provided to the defendant at the final pretrial conference scheduled for September 25th. September 25th, that's 4 days before the trial. The United States expects its case in chief to take approximately 2 days, and it is reasonable to expect that the evidence in the prosecution's case will have been presented by Tuesday afternoon or Wednesday morning. The defendant has indicated in court that he does not plan to present evidence. The only thing that's not evidentiary is a claim that I don't believe I have a duty. The rest is hard numbers. The government has these W-4 forms, these W-2 forms. these tax returns that you did file, and no record of tax returns filed in these other years, and it's all mechanical, made of tangible documents you can hold in your hand. Trouble. Pardon me. Statement of facts. Defendant James R. Back has been employed for over 30 years by Alyeska Pipeline Service Company as a pipeline technician. 30 years, and he threw it all to the wind for the sake of Pete Hendrickson. Alyeska personnel records to be offered at trial will establish that the defendant earned the following wages during the prosecution years. Doesn't matter if they're wages. What matters is if they're gross income. I want to see the definition of gross income. I want to see a reference to 26 U.S.C. 61A, gross income. They just talk about wages. And you have these categories, all the years, and then gross wages. It better be gross income. Taxable wages. You mean taxable income. 63A. Taxable income is gross income minus allowable deductions. And then the 401k contributions. I hope you can sense aggression in my approach, because this whole document is out of line on vagaries. It hits a couple solid points when it serves the government, and the rest of the time they're running from the language that governs this entire controversy. Count 1, false tax returns, 2006. This is a 2014 case. Defendant did not file a 2006 individual income tax return. Instead, he filed a delinquent return, which was purportedly signed on August 15th of 2007. August 15th is the end of an extension, when you request an extension, but was not received by the IRS until April 12th of 2008, 7 or 8 months later. This return claimed that Back earned zero wages. No, didn't it in fact claim that he earned zero in gross income? An income tax return is for the reporting of gross income. 6012 says, who has to file a return? Anybody that has wages. No, it doesn't. It says anybody who has gross income that equals or exceeds the exemption amount. This language in this sentence represents the government's presumption that all wages are gross income. And if you don't start in Section 83, you lose Section 83. And they shuffle you off into 61A, gross income. Now, what are the allowable deductions? Okay, you skipped out on this much tax. You should have filed a return. This tax return over here is false. And they just skip right over the law. Let's see, and demanded a refund of withholdings in the amount of $38,000. Thus included, it should say, this included the federal tax that has been withheld and paid over to U.S. Treasury by Alyeska, as well as the Social Security and Medicare taxes withheld. I'm not the citizen of Social Security. They said I'm a U.S. citizen. And they can't deny a word of this. Remember? Let me give you the address very quickly of they can't deny a word of this. gov't.com/orth, capital O, RTH. Go to that page and you'll see an exchange of briefs between me and the 7th Circuit, the government, in the summer of 2018. And they can't even talk about the definition of citizen and Social Security. They got no business. And here they are complaining that, oh, he demanded a refund for that, when they've had my briefing on this since 1993. Let me delete that for me. On May 16, 2008, the IRS issued a refund check of $33,000. Back endorsed the check and deposited it into his E-Trade account. He didn't stash it. He didn't go get cash. Didn't bury it in the backyard. Full disclosure, this is the conduct of somebody that thinks they're innocent. The balance in his E-Trade checking account at the end of 2006 was approximately $235,000, Your Honor. Remember, he was making $125,000 a year, generally, as the Alyeska pipeline technician. And so here he is. He's cash rich compared to everybody I know. He's not a big man, but he's making, what does that turn out to be? 10 or 12,000 bucks a month, 3,000 bucks a week. Count 2, false tax return. Same. He asked for a refund. He endorsed and put it in his E-Trade account. Same. Let's see. And here we get into it. I'm on page 4 of 24. In July of 2009, BAC received notice for the IRS, should say from the IRS, that the false statements in his 2007 return had been identified. BAC was informed that he owed 30,000 bucks in 2007, plus penalties and interest, based on the discovery that BAC had reported 0 wages, when in fact he had earned 100 a quarter from Alyeska. A statutory notice of deficiency was sent to him in October of 2009, and he appealed with no success. BAC filed a petition in U.S. Tax Court in January of 2010. Okay? Here's a note about Tax Court. Is this evidence of a lack of willfulness? Most definitely. Just because they said it was frivolous, did they prove it was frivolous? And just because Tax Court says so, is somebody supposed to change their beliefs? Oh yeah, you better, say the public servants. Here are 2 quotes from Tax Court. This is ugly. The logical force requiring rejection of their arguments, apart from their assertions of personal political philosophy which do not provide a basis for us, a court sitting to interpret the law, to decide questions dispositive of this case. Oh, is that right? Yeah, that's right. That's what they say. So we need, he needs to bring a challenge at law. And then the next year, this is 1 year apart. Okay, this was Rowley versus Commissioner, 1983. And here's 1984, U.S. Tax Court, 1 year later. This one says, oh, he didn't bring us any issues at law, so we better penalize him. And the next year they say, the pleadings do not raise a genuine issue of material fact respecting respondents' determinations, but rather involve only issues at law. Therefore, respondent's motion, the IRS's motion for judgment on the pleadings, will be granted. The final matter we consider is penalties. So in the first year, 1983, now we're going to penalize you for not bringing us issues at law. We're a court of law. And the next year, oh, we're going to, you had it now, man. You asked us to decide issues at law. Can you hear that? So, whenever the government cites U.S. Tax Court against me in any particular case that I'm contributing to, I raise these two and say, can we step out of Tax Court and just ignore it now? They're on judicial holiday since 1984. And it usually works. Now, trial was held in Tax Court in Palmer, Alaska, June of 2011, before Judge Juan Vasquez. BAC agreed that he received 100 a quarter from Alyeska in 2007, but denied that he had to pay taxes on the money. No, he didn't. He stated that he didn't have to pay taxes on the money. The next sentence, he also stated, well, up here it was denied. How come in the next sentence it's stated? See, that's loose language. They have to throw things around to find some place they can rest. He denied that he had to pay taxes on the money. That's somebody who is not willful and therefore is innocent. I don't owe the money. That's somebody who believes they haven't broken the law. He also stated that they don't have any proof that I received money from Alyeska. BAC argued that the proof that he received money from Alyeska was all hearsay. So what? Get to the part where the law imposes a tax. He denied being a taxpayer. Well, a taxpayer is somebody that owes the tax. So he denied being somebody that owed the tax. It's right here in the memorandum that he's innocent. And claimed that the income was not taxable. No, he claimed that his wages were not taxable. Remember, he reported 0 in wages. See, I could accidentally trip them up, but because every judge is corrupt, they get away with this. The defendant admitted that he had learned the information he was arguing from the internet, among other places. He admitted it. Oh, he admits that he learned something from the internet. Oh, he admitted it, Your Honor. Okay, well, Doesn't the DOJ have a website? So we better not admit we looked at the government website, because you know every one of them is a bunch of crap. Do you admit that you looked at the government's website? Oh, yeah, I did. Gee. They're just throwing crap at people, at an innocent man, is what they're doing. The judge informed Back that he was wrong and that his arguments were frivolous. On July of 2011, the judge issued an opinion holding that Back's arguments were frivolous and groundless, and ordered that the deficiency of $30,000 be paid, along with a penalty of $7,500. Back has never paid the deficiency. His appeal to the Ninth Circuit was dismissed as untimely. Okay. This is sickening. Called him frivolous and groundless. On the Seventh Circuit last year in the Robert Orth case, they called statute outlandish theory. And nobody was even expected for one moment to mention any of the statutes relied upon when it's the definition of citizen out of Social Security chapters. It's Section 83 that explains how to tax the workforce. Nobody had to mention a thing. Section 1, the graduated income tax, doesn't mention anybody's citizenship, but its implementing regulation does. But if you challenge the regulation as inconsistent with statute, you'll be penalized thousands of dollars by people that think a citizen of the possessions in Social Security chapters is a U.S. citizen. Count 3, false tax return. Same. He reported zero wages, got a refund check, put it in his E-Trade account, and look at the bottom of the paragraph here. I'm on count 3, false 2008 tax return. During 2008, Back purchased approximately $156,000 in gold and silver coins from Bullion Direct. So, that's legal. He purchased a house. He purchased diapers for the local battered women's shelter for women with children. Whatever. If it's legal, shut up. It's perfectly legal. What would you buy with it? Let me guess. Sex robots. Well, they're U.S. attorneys. And so you know, and I don't even have to lead you down that path. We know they're deviants. And this document is proof of it. Count 4, failure to file. In such a year, despite earning $125 from Alyeska, in addition to other income. Oh, this time they call it income instead of wages. Let's see. During 2009, he purchased $100,000 in gold coins. Okay. Failure to file tax return, count 5. Same. Purchased gold. Count 6, failure to file a return. Same. And this, he's quoted here. Count 6. I'm on page 6 of 24. Count 6. Defendant failed to file Form 1040 for the year despite earning $138,000 in income or wages. Which one? They don't even say. This is a homework assignment for junior prosecutors. In an account application with E-Trade dated March of 2012, just before the 2011 return was due, Back acknowledged that he was employed by Alyeska Pipeline, okay, that he earned annual income. I thought he reported wages. Now it's reported income because it serves the government to say so. Between $1 and $200,000, that his liquid net worth was half to a full million, that his total net worth was half to a full million, that he was a U.S. citizen. Oh, that's going to get you in trouble. Don't they ram that down our throats? And here they accuse him of admitting he was a U.S. citizen and that his country of legal residence was the United States. Didn't make the non-resident alien claim, although Pete Hendrickson does. It doesn't sound from that comment anyway. March 29th of 2012, Back opened 2 new accounts at E-Trade. He deposited without trying to hide a thing. In Alonis versus United States, 2015, Supreme Court, citing U.S. versus Morissette, the Supreme Court said in 1952 that he obviously didn't have any criminal intent. He carried out his conduct right in public, didn't try to cover a thing, and when the investigators found him, He told him exactly what he had done, and that's what he's being prosecuted for, when he obviously doesn't believe he broke the law. Well, here James Back is doing everything right out in the open. Yeah, E-Trade account. They don't say he used 2 names, 2 social security numbers. They don't say any of that. He was just managing his property. Count 7, failure to file 2012 return on $132,000 in pay. He acknowledged that he was employed by Alaska Pipeline, that he earned an annual income of $100,000 to $200,000, that his net worth was $200,000 to $500,000, that his total net worth was $1 million plus, that he was a citizen of the U.S., and his residency was the United States. What's wrong with any of that? They're looking for things to say to make it look like they told the court something, when it's BS. During 2012, Back purchased approximately 20,000 in silver coins from Bullion Direct. So, it's called a purchase. If he'd have bought Cheerios, a warehouse full of vodka, it's all legal. And here we meet the law. I'm on page 7 of 24. Elements of the offense. The indictment charges the defendant with 3 counts of making and subscribing a materially false tax return in violation of 7206. In order for the defendant to be found guilty of that charge, the government must prove each of the following elements beyond a reasonable doubt. Watch. First, the defendant made and signed a tax return for the years 2006, 7, and 8 that he knew contained false information as to a material matter. Wrong. The first one is this, that he knew he had a duty. And they put it third. It's a criminal jury instruction, so it's right off the books. But the government's influence is found in that fact. Second, the return contained a written declaration that it was being signed subject to the penalties of perjury. And third, in filing the false tax return, the defendant acted willfully. A matter is material if it had a natural tendency to influence or was capable of influencing the decisions or activities of the Internal Revenue Service. He has to have acted willfully. Did he believe he was lying? He signed it under penalties of perjury. How is that not evidence of innocence? He obviously believed he was following the law. No, he didn't. We'll get an indictment and we'll get this guy thrown in prison. False information is material if it had a natural tendency to influence or was capable of influencing or affecting the ability of the IRS to audit or verify the accuracy of the return or a related return, even though they ignored the language of Section 83 in all matters. So, general, it helps them, but when it comes down to it, really, they're talking out of theirs, is what they're doing. Citing U.S. versus Gowden, material statement has a natural tendency to influence or be capable of influencing the decision of the decision-making body to which it was addressed. Okay. District courts should instruct on materiality, tracking the language of Gowden. The fact that an individual's name is signed to a return statement or other document shall be prima facie evidence for all purposes that the return statement or other document was actually signed by him. And it should say, and also that it indicates they don't think they're breaking the law because it's under penalties of perjury. Oh, we can't say that, or else we won't be able to send innocent people to prison. The defendant is also charged in the indictment with 4 counts of willful failure to file income tax return, 7203. In order for the defendant to be found guilty of that charge, the government must prove each of the following elements beyond a reasonable doubt. First, the defendant was required to file the return for the calendar years. How did Section 83 operate in year determination? He had gross income that triggered the return filing requirement under 6012. They can't talk about it. It's off limits. They never consider Section 83. And yet, it explains how to tax the workforce. Houston, we have a problem. You got to give me a break. Second, the defendant failed to file an income tax return by the due date. And third, in failing to do so, he acted willfully, meaning he knew he had to file and he chose not to. Okay. In order to prove that the defendant acted willfully, and we're getting right down to it now. Tax returns signed under penalties of perjury, saying I made zero. And they never even asked him, you talking about zero wages or zero gross income? And because he's a student of Pete Hendrickson, he wouldn't have been able to answer anyway. Because the movement keeps people stupid. In order to prove that he acted willfully, the government must prove beyond a reasonable doubt that defendant knew federal tax law imposed a duty on him and the defendant intentionally and voluntarily violated that duty. How can you know the law imposes a duty when it's a secret? They'll penalize you thousands of dollars for arguing for Section 83. Kentucky, U.S. District Court. The DOJ sued a man saying, hey, we want this real estate, and we're going to convert these IRS liens and assessments into real estate. He lost that real estate to his wife years before, and so he had nothing to lose. And I said, it's a shame to watch somebody sit around and get sued. You want to countersue him? He said, yeah. So we looked at the Taxpayers' Bill of Rights. Clause 1, it says you're entitled to clear explanation of the laws. And so he countersued them for the clear explanation of the laws they have to have. They're charged with properly obeying the law. And they dismissed his counterclaim. You can't have clear explanations of the law. You can't have them. So how are you going to allege that I knew federal tax law imposed a duty on me when it's a secret? Listen to this jury instruction. Ninth Circuit Model Criminal Jury Instruction 9.42. A defendant who acts on a good faith misunderstanding as to the requirements of the law does not act willfully, even if his understanding of the law is wrong or unreasonable. Nevertheless, merely disagreeing with the law, that means a protest, does not constitute a good faith misunderstanding of the law, because all persons have a duty to obey the law whether or not they agree with it. Thus, in order to prove that the defendant acted willfully, the government must prove beyond a reasonable doubt that the defendant did not have a good faith belief that he was complying with the law. I got tax returns here signed under penalties of perjury. Zero. How do you go to a grand jury and say he believes he has a duty? He just swore that he doesn't believe he has a duty. It's not good enough for the government. You got to swear under penalties of perjury so we can ignore it later. Can you hear those wheels cranking on your loved ones, your child's future? Next paragraph. 7203 and 7206 of the Internal Revenue Code use the term willfully. In Cheek v. U.S. Supreme Court 91, the Supreme Court set forth the following definition, quote, willfulness, as construed by our prior decisions in criminal tax cases, requires the government to prove that the law imposed a duty on the defendant, that the defendant knew of this duty, and that he voluntarily and intentionally violated that duty, end quote. This same definition applies equally to all tax offenses, misdemeanors, and felonies alike. See U.S. v. Pomponio, citing U.S. v. Bishop, both Supreme Court cases, respectively 76 and 73. Quote, in other words, if you know that you owe taxes and you do not pay them, you have acted willfully, end quote. U.S. v. Easterday, 9th Circuit, 2009. In a failure to file tax return prosecution, the government is not required to prove an intent to evade or defeat a tax, but may instead prove an intent to disobey or disregard the law, which may be the intent not to file a return rather than the intent to defeat or evade a tax. We don't even have to get into that for this case. A defendant's views regarding the validity of a tax statute is irrelevant to the issue of willfulness, and, if heard, the jury should be instructed to disregard such views. Cheek v. U.S. And then they cite U.S. v. Powell, 9th Circuit, 92. No plain error to instruct that mere disagreement with the law in and of itself does not constitute a good faith misunderstanding of the requirements of the law, because it is the duty of all persons to obey the law whether or not they agree with it. End quote of that case. Willfulness is a state of mind that may be established by evidence of fraudulent acts. Fraudulent acts, he's buying gold and silver. He set up a trust. He's got an offshore bank account. Well, it's obvious he believes you're stealing from him. The tax return was signed under penalties of perjury. He might have a criminal complaint on file against the government. And wouldn't you hide your money from a thief? Oh, it's circumstantial evidence, and we got him now. See U.S. versus Mirabel's 9th Circuit 84, listing acts from which willfulness can be inferred in evasion case. U.S. versus Tucker, 9th Circuit 98, false returns. A defendant's past tax-paying history is admissible to prove willfulness, circumstantiality. They cite U.S. versus Schiff, 2nd Circuit 79. Schiff, I wonder who that was. Proof of willfulness included previously filed corporate and personal returns and reminder by accountant. This may include years prior or subsequent to the prosecution period. Okay. We're on penalties upon conviction, page 11 of 24. Upon conviction of each of counts 1, 2, and 3, the defendant is subject to a maximum term of imprisonment of 3 years, maximum $250,000 in fines, a term of supervised release not to exceed 1 year, and costs of prosecution. Upon conviction of each count 4, 5, 6, and 7, the defendant is subject to a maximum term of 1 year, max fine of $100,000, and a term of supervised release not to exceed 1 year. Cost of prosecution must be imposed by the court in the event of a conviction. The grammatical structure of the statute and the use of the word shall compel the conclusion that the provision is mandatory. He shall pay restitution. Or court costs, Evidentiary issues, bottom of page 11. Willfulness has been defined by the courts as a voluntary, intentional violation of a known legal duty. The law is a secret. How do you say it's a known legal duty? They're still sending people to prison. They've had my briefing since 93, and they can't refute it. Bottom of page 11. Therefore, in order to establish willfulness, the government must establish that the defendant was aware of his obligations under the tax laws. Show me. When determining whether a defendant has acted willfully, the jury must apply a subjective standard. Thus, a defendant asserting a good faith defense is not required to have been objectively reasonable in his misunderstanding of his legal duties or belief that he was in compliance with the law. And that's not good enough for them, obviously. We got our eyes open, don't we? Although ignorance and misunderstanding of the law may be asserted in an attempt to negate willfulness, disagreement with the constitutional validity of the law may not. Once it has been established that the defendant was aware of a legal duty and intentionally violated that duty, it is no defense that the defendant believed that the law imposing the duty was unconstitutional. The constitutionality of the tax law is to be litigated by taxpayers in other ways established by Congress. Up yours. We tried that across the country for the last 5 years. 2 lawsuits, South Dakota. 2 lawsuits, South Carolina. Counterclaim, Kentucky. Texas, tax court. Appeals on the 7th, 9th, and 11th circuits. Those 3 appealed to the Supreme Court. You can't have tax law. Any question? To prove willfulness, the government must show that 1, the law imposed a duty on the defendant. 2, the defendant knew of that duty. And 3, the defendant voluntarily and intentionally violated that duty. Willfulness is rarely subject to direct proof and must generally be inferred from a defendant's acts or conduct. And what they do with witnesses here is just atrocious. Bottom of page 12. Near the end of its case, the government expects to call an expert or summary witness trained in taxation and accounting that has no knowledge of Section 83 of the Tax Code. This witness will provide an analysis of the financial records introduced into evidence and explain the tax consequences of the evidence. Don't they have to arise from the operation of the law? Tax consequences? But we are unfamiliar with Tax Code Section 83, including whether or not Back earned wages. I thought it was income. No, it's wages this time. Or was entitled to the refunds, and whether he earned enough gross income to require him to file Oh, finally, we mentioned gross income and that triggers the requirement to file a tax return, and whether he earned enough gross income to require him to file a return in the later years. The federal rules of evidence authorize the use of an expert witness if it will assist the trier of fact to understand the evidence or to determine a fact in issue. The courts have traditionally allowed summary expert testimony in tax prosecutions, but we can't hear from your neighbors and your friends or your spouse as to what your beliefs were. We're coming to it. The qualifications of the witness have been provided in compliance with the rules. Oh, sure. Summaries. I'm going to skip this. Potential defenses. And we're moving along, I guess. Okay. Potential defenses. United States asked the court to exclude arguments, exhibits, and testimony regarding matters which are irrelevant to the factual determinations to be made by the jury in the instant case, and which will also be substantially more prejudicial than probative. Based on the defendant's pretrial motions, the government anticipates that the defendant will try to present legal arguments and evidence regarding his assertion that the prosecution must present evidence from witnesses with personal knowledge that the Constitution and the Code apply to the defendant. Oh no, he's just a rabble-rouser, isn't he, to demand that. Such exhibits, testimony, and arguments constitute incorrect statements of law. Haven't heard them yet. And invade the province of the court to instruct the jury on the law. I'd rather have Congress instruct me on the law. Thank you very much. Here's the law. Allowing such arguments and evidence will confuse the jury as to their true role of determining the factual issues before them, as opposed to making determinations on the law. The United States respectfully asks the court, therefore, to limit the jury's exposure to the arguments that are not relevant to the factual issues the jury must decide. The United States seeks to prevent the defense from arguing or presenting evidence regarding incorrect interpretations of the law, self-serving hearsay, or speculation from witnesses regarding the contents of the defendant's mind. That's part of their conduct. How did the defendant act? Are you kidding? He had a picket sign in front of the IRS building downtown. Are you kidding? He was filing notices with Congress and chasing this down. I've known him for years, and it's what he does. Oh, you're not allowed to say that. You're just a witness to the truth, and so we can't have that. We're going to rely on experts and a jury that doesn't know the defendant. You got to let that sink in. The United States, this is on page 14, the last sentence. The United States seek to prevent the defense from arguing or presenting evidence regarding incorrect interpretations of the law, self-serving hearsay, or speculation from witnesses regarding the contents of the defendant's mind. It's not speculation. I watched him put those tax returns in the mail. He urged me to go to this seminar that so-and-so was teaching about how the IRS is stealing everything it gets. Well, that's irrelevant. You're just a witness to the truth. We're going to rely on an expert and a jury, none of whom even know the guy on trial. Page 15. Defendant should not offer incorrect interpretations of the law during opening statement or closing arguments. Great. The court has to instruct the jury on the law. That's fine, but I want to know the judge knows what he's talking about before he does it. I want to know what the judge is going to tell the jury about Section 83 so I can appeal it right now rather than go to trial and get convicted and thrown in prison pending appeal. And I'm on the bottom of page 15. The law is given to the jury by the court and not introduced as evidence. Obviously, it would be most confusing to a jury to have legal material introduced as evidence and then argued as to what the law is or ought to be. Juries only decide facts to which they apply the law given to them by the judge. Well, I want to see the manual for judges on how to instruct the jury in a case like this. I want full disclosure of what you're going to instruct the jury on. Can't. We aren't going to do it. Page 16. The defendant's arguments must be limited to the facts presented during trial and the instructions given by this court. The defendant is permitted to argue that he lacked the requisite willfulness to commit the crimes with which he is charged based upon a good faith misunderstanding of his duty under the law. It says, U.S. versus Cheek, government's required to rebut the claim of good faith misunderstanding or ignorance of the law. I'll tell you what, people trained on my findings, that right there, that's what gets IRS criminal investigation shut down and nullifies tax grand jury. The government is required to rebut the claim of a good faith misunderstanding or ignorance of the law. They had their chance on the 7th Circuit, 9th Circuit, and 11th Circuit last year, 2018. And those three petitioned the Supreme Court. You can't have the law. And middle of the page, citing U.S. versus Whiteside, 5th Circuit, 87. Approving of jury instructions stating that the defendant's conduct is not willful if he acted through negligence, inadvertence, justifiable excuse, mistake, or due to his good faith misunderstanding of the requirements of the law. Okay. And the government goes on in this paragraph here, end quote. A disagreement with the law, however, is not a defense to the crimes alleged in the indictment. That's right. It has to be a good faith misunderstanding, not a disagreement with the law. Let's see. I'm going to scroll here. You can stop this at any time, read this. Download the document and read it. Let's see. I'm on page 17. B. Defendant should not be permitted to present irrelevant evidence to the jury. Under federal rules of evidence, the jury shall not be exposed to inadmissible evidence. Evidence which is not relevant is not admissible. Relevant evidence, moreover, is evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Thank you. The primary issue in this case will be the defendant's willfulness. Thus, the relevance of most evidence will depend on how probative it is of the defendant's state of mind. The defendant likely will argue that certain evidence is necessary to demonstrate that he held a good faith belief that he was not required to file in 09 and 012, and that he honestly believed he was entitled to a full refund of all the federal income, Social Security, Medicare taxes paid for those years. The defendant, however, is only permitted to introduce factual evidence upon which he relied during those years to form his opinions about the laws. Swear me in. Get me on the witness stand. Here's a bunch of facts. I didn't believe then. I don't believe now. I've read the law. That's not my citizenship and Social Security. Damn right I want a refund. How does Section 83 operate when you impose Social Security on me? They can't even talk about it. And yet this man is utterly unprepared and went to trial and stammered his way into a 16-month sentence, guilty on all counts. Top of page 18. Thus, evidence presented by the defendant in support of his interpretation of the law should be excluded, unless the defendant lays a proper foundation to reveal, 1, the evidence was seen prior to the defendant forming his beliefs, as opposed to after the beliefs were already formed. 2, an explanation of how such evidence helped form his beliefs in order to prove such information was relied upon by the defendant and was instrumental in forming his views. And 3, the defendant is not self-serving hearsay. The evidence is not self-serving hearsay which the defendant helped create in support of his already existing beliefs. Wow, you fussy bitches. You can't even explain the law. And listen to the way they're tightening the screws on this man they know to be innocent. I'm still on page 18, next to the last paragraph. A document or conversation is not relevant to the defendant's state of mind unless he relied upon it in making his decision to claim refunds. He relied upon a conversation to claim refunds? Or to not file tax returns. It hurts, okay? The deficiencies and inadequacies in the brains of people with such power is always a slap in the face. Moreover, such conversations and documents are only relevant if the defendant was exposed to them prior to the date he committed the crime. Furthermore, only the defendant can lay the proper foundation for the above-mentioned evidence, and he must do it by testifying in court from the witness stand, not the podium. No objections. Get me on the stand. I got a lot to say. Bottom of page 18. Let's see. I'm going to skip this. You can read it here or download the document. It's about whether or not he can present hearsay testimony. We don't need to cover that. Oh, actually, let's do that. Bottom of page 18, it's C. It is not permissible for either the government or defense witnesses to express their opinion as to what the defendant purportedly believed, as this calls for speculation regarding the true contents of the defendant's mind. What if the defendant told his friend all the time, I don't have a duty? I'm not testifying as to the contents of his mind. I'm telling you about the contents of his speech. And you'll lose on it. They'll never let anybody anybody testify, yeah, I'm the spouse of the defendant. We sleep in the same bed every night, have for this many years. He doesn't believe, she doesn't believe they have a duty. Oh, we can't admit that. The issue of whether the defendant truly believed, albeit mistakenly, that he was not required to file tax returns or pay income taxes is an ultimate issue of fact for the jury alone to decide. They can't afford to have witnesses. They're skating on thin ice. Their ass is flapping in the breeze in every tax case. And they cite U.S. versus Howard, 7th Circuit 94, quote, by the nature of a tax protester case, defendant's beliefs about the propriety of his filing returns and paying taxes, which are closely related to defendant's knowledge about tax laws and defendant's state of mind in protesting his taxpayer status, are ordinarily not a proper subject for lay witnesses' opinion testimony, absent careful groundwork in special circumstances. Opinion testimony? It's not opinion. He told me all the time he wasn't liable. That's not opinion. It's eyewitness to a fact. They heard speech that said, I'm not required to file. Anyway, another case, U.S. versus Rhea, 92, 2nd Circuit. Witness testimony regarding defendant's observation that the defendant was told, witness testimony regarding a defendant's observations, what the defendant was told, and what the defendant said or did will often not be helpful within the meaning of Rule 701 because the jury will be in as good a position as the witness to draw the inference as to whether or not the defendant knew. Horse crap. Who's the witness? Under this, they'll even they'll bar a spouse from testifying as to what their spouse's beliefs were. And you lose. The government is a coward when it's not a child molester. Opinion of lay witness that defendant indicated he understood what he was doing gave no objective basis for the jury to determine the defendant's state of mind. Why not? He's a witness. It's because we can't afford that kind of testimony in a tax trial. We're the government. Bottom of page 19, reliance on counsel. Goes without saying. It's a good topic to know. Reliance upon counsel or an accountant means you're not willful. Jury nullification. The jury can nullify the decision, but it's not because they have a right to. They have the authority to reject what the court says. And I'll tell you what, you get me on the stand, and I'm going to I'll put a wave through the courtroom with what I'm able to tell the jury. Let's see here. I'm scrolling. Download the document if you want to read all this. Issues regarding pro se representation. And I'm at the top of page 22, right at the end here. Continuance on the eve of trial is not required. Okay, I don't want to read about a continuance. The defendant can't get it together yet. We need a continuance before we go to trial. Pro se with Jamie McGrady appointed as standby counsel. Defendant cannot testify from the podium or through arguments or with statements to witnesses. That means they better organize very well their oral testimony for the witness stand. That's where you have to say it. Don't forget it. And then the last page, 24. Liberty and justice for toilet paper. Look at all that we just saw in one document. But the takeaway from this is right here, Model Criminal Jury Instruction 9.42. And this whole, in yellow, discussion of what is and is not willfulness. Because it's one of the definitions of innocence. One definition of innocence, hey, I filed my tax returns on time. What are you talking about? Oh, sorry. Hey, I paid taxes those years. What are you talking about? Oh, sorry. Hey, I didn't have criminal intent. And you don't hear, oh, sorry. You hear, who cares? And you go to prison. In this regard, the U.S. is every bit as bad as Central America or China. They know innocent people are going to prison, and you're looking at a homework assignment for junior prosecutors. Wrote this. Copy and pasted out of a bunch of others, and they were told, just try to make it sound like you're saying something, throw in some extra stuff it doesn't matter if it's irrelevant. The judge will ignore it, but at least our memorandum will be longer that way, when they didn't even cite the statute that makes wages gross income. So, the James Back trial memorandum, 16 months in federal prison on those 7 counts, guilty on all counts. He was making $125,000 a year, and he threw it all to the wind for Pete Hendrickson, who insists, oh, he must have done something wrong. Excuse me, they won't even talk about Section 83 that explains how to tax the workforce. You think it matters whether or not you file a tax return like that the right or wrong way? You lose. Those are the rules. You lose. When you contradict the government, you lose. And they don't need the law. They don't need a correct procedure. They simply reach out and squash you like a bug. Just ask James R. Back. This is a 2014 memorandum, September 22nd of 2014, right there, a week before trial. And so here, a week before trial, a pro se litigant has this trial memorandum laid on him by the DOJ when they know he's innocent. And they're determined to take him to trial and stick him in prison. And you're going to file a funky tax return? You're going to invite a relationship with a government like this? The government, municipal, state, and fed, they're not strict cops. They're carjackers with a pistol. And they will get your money, even if they have to steal it. And so I'm out here trying to get people, keep people out of prison by saying, just don't do this. And Pete Hendrickson, the tax honesty movement, is over there saying, do this, and I don't care if you get in trouble. I'm an advocate. They're morons. I'm a whistleblower. They're shysters and tax protesters. Huge difference. Anyway, the takeaway from this, the definition of innocence, if you don't file, if you don't pay, you need to impress somebody with the fact that at a certain point in time, you acquired a belief, because they won't let your friends testify, and they'll infer it based on facts. And omit other relevant facts that you might not think to bring up, because your appointed counsel is dirt poor of knowledge about the tax code. So, just another tip from your Uncle Dave: stay out of trouble. This is the way to do it. You got to know where the line is drawn and decide whether or not you want to walk it. Personally, I think it's worth it to pay the government what they say you owe, just so you don't have a relationship with a bunch of public servants that think the law should remain a secret and that they should put innocent people in prison. Why would you do that? So, be careful, be well. None of this is legal advice. My name is David Myrland. It's been my pleasure. I'll see you on the next tutorial here on Take from Caesar.